imposing of formalities on both enjoyment and enforcement of the works. Our response, Honourable Chair and members, is that we maintain the clauses 5 and 10 of the bill as proposed because of the following reasons. Whereas we appreciate that there are no formalities to the enjoyment of the works and enforcement as per the Berne Convention of 1886, there are so many emerging issues that have come on board. The proposal is intended to protect the vulnerable creators who sign away their rights in unfair and opaque contracts. And this has been a complaint from the artists that they signed contracts without knowledge and signed their rights in perpetuity. The other reason is to ensure that there's transparency in the industry. Failure to register the contracts creates uncertainty among the sector players, and this limits the commercialization of copyright, like the use of copyright as a collateral is one of the examples. Registration also would create a comprehensive database of rights determination, which protects all parties involved in the ecosystem and increase the viability of copywriters for commercialization. The other reasoning is that the contracts involving the foreign parties are usually governed by other laws. There's already a legislative system, the Copyright Act, that regulates and guides the contracts generally, and in most instances, if not at all, will not apply. The parties will also be at liberty to choose the law if the assignment involves the foreigners, because there's freedom of contracting in Uganda. The bill does not contravene the Berne Convention as stated by the stakeholders. The Berne Convention of 1886 is, and the Article 20 that has been referred to of the WIPO for performances and phonograms treaty only provide for protection and enjoyment of copyright as an automatic right, and this principle must be maintained. Yes, to get copyright, it must be expressed, it must be put in tangible form, and there must be some level of creativity, and so it is automatically protected. The issues relating to registration to enhance the evidential value of every transaction that is involved in the copyright ecosystem. So there's no international treaty that regulates copyright contracts at all, and the bill intends to provide for just regulation of contracts relating to copyright. The other issue is that the courts are already empowered to adjudicate over contracts and determine the unfairness and reasonableness, and so there's no need to worry. On page 3, the other concern by the members was that the bill also contravenes Section 3.2 of the Principal Act, which provides that the protection of works of the author shall not be subject to any formality. The registration is cumbersome and costly given the financial position of many creatives. The non-registration will lead to loss of property, yet copyright is inherent, an inherent right for works invented, and that the creative, it will create predatory behavior, since people are likely to register works that are not theirs because they acted faster than the creatives. The response is that the registrar should not be empowered to reject the registration of copyright due to the party autonomy principle under the contract law, because it's already taken care of by the contract laws. Then the issue of registration fees is addressed by the minister through the regulations, and these fees are never deterrent, and in any case they are to enhance the protection system, because we're looking at a balancing of rights. Since copyright is a private right, the members should appreciate, the stakeholders should appreciate that we have to put protection mechanisms around their rights. The non-registration of contracts will not affect the ownership of copyright, because registration is optional, and if it is not registered, it will not affect the ownership at all. So there's no need to worry as expressed by the stakeholders. The other issue is that the registration is not for copyright works in this case, but for the transactions, because these are transactional matters, Mr. Chair and honorable members, and any transactional agreements which affect the benefits and not the works themselves must be registered for transparency, for accountability, for tracking, and for sustainability, among others. Regarding Clause 6, which provides for insertion of Section 13A, 13B in the Principal Act to provide the reversion of rights after 20 years back to the author, the stakeholders' concerns are that they are objecting to the proposal on the following grounds: that the provision will frustrate the freedom of contract and unlawfully deprive the copyright owners of full utilization of their rights. And the other concern from the stakeholders is that the provision risks fragmenting the rights owned by individual rights owners in the copyright works and deny each party the right on their own and to individually license and fully utilize the rights in the copyright. Honorable Chair and members, our proposal is that the proposed amendment should be maintained because it is intended to protect both the authors and the creatives of copyright works from the consequences of their inadvertent transfer of rights. This provision was introduced in the bill upon request from the creatives themselves and the complaints that they have signed contracts in perpetuity that are not defined and do not indicate any terms, and it is very difficult to follow up on the matters that relate to the assignments and transfers, among others. And so it is to enhance their protection in respect to the contracts deemed to be unfair at the time of execution. And we beg that this should be maintained because it's for their own benefit. And the same stakeholders who have been complaining about the lack of clarity under the law in terms of the reversion of rights. And so 20 years is ideal. In some countries, they provide 25 to 30 years as well. And also this is, will help their heirs, the heirs to these creatives in terms of the commercial, moral, and economic benefits of their works. The other concern is listed on page 4, and these have been responded to by the fact that we submit that the clause should be maintained for the reasons that have been given. All these reasons that have been given are to balance the rights between the owners of rights, but also the creative industry, and it is in their own benefit that we maintain this provision. And honorable members, actually the proposals and all these clauses are for the benefit of the creatives to the biggest extent. On page 5, honorable Chair and members, it refers to clause 8, the insertion of section 14A and 14B to provide for the orphan works and the restrictions on reprographic copying. The stakeholders raised the following concerns: that in the proposed subsection 14B2, the provision restricts the exercise of the minister's discretion to only persons who cannot be identified, yet the definition of orphan works includes persons who cannot be found as well as those who cannot be identified. The other concern is that whereas the provision grants all economic rights to a person licensed to protect, to exploit orphan works by the minister, the provision does not contain the requirement on the license to compensate the author of orphan works and collecting society, if any, and for exploitation of the orphan works in the situation where the author is identified and found. The other concern by the stakeholder is that the provision does not prescribe the period for the license issued by the minister to exploit the orphan works, and that the provision does not recognize the role of collective management societies in the licensing of orphan works which they manage. The stakeholders also propose the following if the provision is to remain part of the bill. Their proposal is to the effect that they require an applicant seeking a license to exploit orphan works to obtain a letter of no objection from the relevant collective management organization, or they require the collective management organization where orphan works are managed by the relevant collective management organization to receive applications and issue licenses for exploitation of orphan works instead of the minister. They also require the minister to consult the collective management organizations in issuing regulations for accessing orphan works. And lastly, they require that the minister share with the collective management organizations the monies arising from the licensing of orphans by the orphan works, by the minister. The response, Honorable Chair and Honorable Members, is that we agree with the committee that recommends to amend clause 14B 2 to include persons who cannot be identified as follows: that the minister shall not license a person to exploit an orphan work unless the applicant has demonstrated to the minister that the author of the work cannot be found or identified. We also propose, Honorable Chair and Members, that the other provisions of clause 8 be maintained as provided in the bill because of the following reason. One, a licensee of an orphan work has exploitation rights during the subsistence of the license and cannot be required to compensate the author for the period he or she is holding the license, and the copyright reverts to the author before the expiration of the license. Secondly, the clause 14B 5 empowers the minister to make regulations on such matters like the period of the license, and this will be done in the regulations. We cannot provide this in the main act. The third issue is that collecting societies, which are collecting management organizations, cannot be expected to have rights over orphan works because the author and the owner cannot be found or identified, and so cannot be a member of the collecting society. A collecting society represents the owners of these rights, and so if a work cannot identify the owner, it means that they don't belong to the scope of the collecting society, and so it does not apply. Mr. Chair, on page 6, which refers to clause 11 of the matrix, the insertion of section 39A in the Principal Act relating to the contracts relating to the ring back tunes. The stakeholders agreed that in principle with the proposal, but made a further proposal that clause 11.2a, the author and performer should be separated and each should be given a clear percentage. This is agreed to. The sharing model is clear in the act, and even more clarity will be provided in the regulations. So we agree with this proposal. The next issue is the Office of the Registry of Copyright. The stakeholders propose that Section 40 of the Principal Act be amended to create an Office of the Registrar of Copyright and Assistant Registrars and provide for qualifications, expertise, and experience of the Registrar of Copyright and Assistant Registrars and Copyright Inspectors. They also go ahead to indicate that the Registrar of Copyright and Assistant Registrars, as well as Copyright Inspectors on page 7, should have the expertise in law, investment, or related field with experience and competence to manage the copyright affairs. Mr. Chair, Honorable Chair, and members, we beg submit that the Section 40 of the Act is adequate enough, and the issues of qualifications or expertise as well as experience for Registrar of Copyright and Assistant Registrars, as well as Copyright Inspectors, administrative issues, not legislative, and should not be introduced in the Act. Further, the qualification of the Registrar General, who is currently designated as the Registrar of Copyright, is provided for by the Uganda Registration Services Bureau Act, CAP 217, and is therefore competent to handle copyright and related matters. Under the URSB Act, Honorable Chair and members, the Board of Directors is mandated to appoint other competent officers to support the Registrar General in her duties in accordance with the recruitment procedures of Uganda Registration Services Bureau. In Clause 12, where there's mention of amendment of Section 41 of the Principal Act, and among the others provide additional functions of the registrar, the concerns of the stakeholder is that the quasi-judicial powers of the registrar create a conflict of interest, since the registrar licenses, regulates, and also enforces. They will therefore have to be judges in their own cause if the complainant is challenging a license and or compliance issue. And so their concern is, their proposal is that there's need to separate, for separate regulatory and adjudicatory powers to uphold the principles of fairness and natural justice. And they also propose that there is therefore need for an independent adjudicator, such as a tribunal, to settle disputes. Our response, Honourable Chair and members, is that we maintain Clause 12 of the bill as is, because the quasi-judicial powers of the registrar are subject to the court processes, and a person is at liberty to apply to the courts of judicature if he or she wishes for judicial review. It is also important to note that Uganda Registration Services Bureau has administered quasi-judicial powers under its various laws, to mention the Companies Act, the Trademarks Act, among others, and it has capacity to also handle these under the copyright and neighboring rights legal framework. The bill also proposes for regulations that will address the procedural matters and appeal from such decisions to High Court, as is being done already under the Companies Act and the Trademarks Act, among the acts that we are implementing. The policy objective of these authorities provide an alternative and cost-effective means of conflict resolution in a period where we are promoting alternative dispute resolution. And furthermore, Uganda Registration Services Bureau, as an educator, has no vested interest in the subject matter, namely copyright and neighboring rights and ownership thereof, and there will be no conflict of interest whatsoever. This has been done successfully under the various laws that we implement, and we believe that it's going to address the cost of doing business and access to justice by the creative sector, and should be maintained, and it's in their own interest, Mr. Honourable Chair and Honourable members. Page 8 of the matrix refers to the Clause 17, which proposes the insertion of Section 49A in the Principal Act to provide a blocking, takedown, and measures and obstructing of infringement of infringing content, I beg your pardon. And also Clause 17 of the bill that introduces 47A in the Principal Act to empower the Registrar of Copyright or ownership of the copyright works to issue the takedown orders to online platforms that host infringing content. The stakeholders' concerns are as listed, that they object to the introduction of Clause 49A on grounds that the provision is a veiled attempt to introduce mandatory registration of copyright works in contravention with Section 3(1) and 2 of the Principal Act and the principles under the World Intellectual Property Organization framework, which grants blanket protection to any copyright works without any formalities such as registration. Requirement, they also state that the requirement to present a certificate of registration in order for the registrar to issue takedown orders causes unnecessary delay while allowing another party to infringe on the creative works, especially with the requirement of to gazette for 60 days, which is the requirement under the Electronic Transactions Act. The stakeholders propose that the Clause 49A4 be deleted, and that the process should be simple, shorter period in terms of takedown that should be provided. Honourable Chair and Honourable Members, our proposal is that we maintain Clause 17 as is in the bill. Yes, as is in the bill. Clause 49A, the section 49A 4 of the bill is intended to guide the registrar before a decision is made. The certificate of registration acts as prima facie proof of ownership, which aids the registrar in executing her mandate or his mandate. Requiring the complainant to present a certificate is a safeguard against potential liability of the Registrar of Copyright that should he or she issue a takedown order in respect of the work which does not belong to the claimant. So it is for evidential purposes and it should be maintained. And Honourable Chair and members, it is for the benefit of the authors, the creative industry themselves. Honourable Chair, on Clause 19, still on page 8, does provide amendment for Section 55 of the Principal Act to, among others, prescribe the nature of sufficient evidence. The bill proposes that a certificate of registration may be adequate proof of infringement of copyright, and the concerns of the stakeholders are as follows: that the requirement to specify the registration certificate as evidence that may be presented may be interpreted as giving the registration certificate superiority over other evidence that a person may rely on in proving his or her case, that this will inadvertently create a mandatory obligation to register copyright works in total disregard of the provisions of Section 3 of the Principal Act, which bars any informality of in the protection of copyright works. The stakeholders also state that the certificate of ownership isn't the only conclusive evidence of ownership, since the copyright owners can prove ownership of rights of their works through presentation of original work files, metadata, publishing agreements, licensing, and other evidence of ownership. The other concern is that the provision is a veiled attempt to introduce mandatory registration of the copyright works, contrary to the provisions of Section 3(1) and 2 of the Principal Act, and Article 5(2) of the Berne Convention, and Article 20 of the WIPO Performances and Phonograms Treaty of 1996, which Bill seeks to domesticate. And the other concern is that the proposal on page 9, the proposal in the bill will limit court's discretion to admit any evidence if it deems fit, as on page 10, as an unnecessary requirement in light of the sections 25, 45, 1 and 2 of the Principal Act. The stakeholders propose that Clause 19 of the bill is amended by deleting the proposed subsection 3. Honourable Chair, we beg to submit that we maintain the Clause 19 as is in the bill, because the use of the words may include shows that the certificate is mere alternative evidence where other forms of evidence may be adduced. So it does not leave out the other models of evidence and should be maintained. And we also submit that it is in the interest of the authors of these rights to maintain this provision. Still on page 10, Honourable Chair and members, Clause 20. Clause 20 provides for registration of collecting societies. The stakeholders agreed with the provision but proposed to amend an amendment to 1, provide specific number of people needed to register a collecting society; 2, to provide definition of collecting society; number 3, to provide for all collecting societies should not be for profit organizations. Honourable Chair and members, our submission is that the issue regarding providing of a specific number of people needed to register collecting society is already provided for, and that is the number of members is 30 as provided for in the existing Act, Section 58B. We agree with the proposal that the definition of collecting society should be provided, and this is the proposed definition of collecting society. A collecting society means an organization approved and authorized by the Registry of Copyright, which has as its main objective, or one of its main objectives, the negotiation or the negotiating of the collecting and distribution of royalties and granting licenses in respect of the use of copyright works or neighboring rights. Further, we agree that collecting societies should not be for profit making, but propose an amendment of section 59.2 as follows: that the application shall be accompanied by 3 copies of the proposed articles and rules of the society, a copy of the certificate of incorporation as a company limited by guarantee without share capital, and such other information as may require. So we agree that it should be explicitly stated that they are not for profit making. On page 11, Honorable Chair and members, clause 25, insertion of section 67A to provide for annual general meeting. The stakeholders argued that the penalties for failing to call an annual general meeting are disproportionate to the offense, especially where non-compliance may be due to logistical and financial constraints. Such high penalties will deter qualified individuals from serving as executives on the committees, since they serve voluntarily. The current penal provisions are sufficient. The stakeholders also propose that the proposed section 67A 3 be deleted. Our response, Honorable Chair and members, is that we propose that this provision be maintained. A collective management society is a specialized company which requires a special attention in terms of considering the corporate governance of the collective management society, which is a key benefit for the members. This proposal was made by the stakeholders themselves as a mechanism of holding their collective management societies accountable and to compel them to comply. So the penalty threshold stated is a maximum, and so the court may impose a lesser one on their discretion. The Copyright and Neighbouring Rights Act, Cap 222, does not have any penalties to this effect at the moment. So our proposal is that it be maintained, because it is for the benefit of corporate governance of the collective management societies, and the fact that they're registered as companies, and it is in their own benefit because of the challenges that they've been facing of compliance and accountability. Mr. Chair, the new clauses to provide image rights and artificial intelligence, the stakeholders propose that there is need to provide image rights and artificial intelligence in the copyright law. The response, Honorable Chair and members, is that this proposal be rejected. This is because the image rights are not copyright. The issue of image rights is different and belongs to a different category of personality and privacy law, and is regulated by the Constitution and the data protection, as well as the privacy mechanisms, and we already have the Data Protection and the Privacy Act that regulates this. If they meant photographic rights are protected as artistic works under the copyright law, and a photograph is very clear is eligible for copyright, and the rights belong to the person that takes the photograph. But for image rights, it's a totally different arena, and it's already protected by the Constitution of the Republic of Uganda, the data protection and privacy laws that apply. The issue relating to artificial intelligence is a general concern for all laws across the board, and we believe that this can be handled at a national level by putting in place an artificial intelligence policy, as well as the future consideration that since these are emerging issues. And regarding copyright, artificial intelligence and copyright, these are also embedded in works eligible for copyright. If they are works that relate to computer programs, scientific works, or artistic or literary works, are already provided for. So our proposal is that this proposal be rejected. It is already catered for in other avenues of the law. Mr. Chair, and Honourable Chair and Honourable Members, the other issue is the private copy remuneration. The stakeholders proposed for creation of a private copy remuneration, and according to the stakeholders, the private copy remuneration is a system where creators and rights holders are compensated for the private and non-commercial copying of their works. This typically involves a levy on all devices or media that can be used for copying, like smartphones, blank storage media, and the aim is to provide a fair compensation to creators for the loss of revenue due to private copying, which is generally permitted under the copyright law for personal use. According to the stakeholders, Section 14 of the Principal Act allows for private use of the copyright works under what is called fair use. The fair use doctrine permits the unlicensed use of the copyright works in certain situations. It is an exception to copyright law, allowing the use of copyrighted materials without permission for purposes of news, reporting, teaching, scholarships, and research, or persons with disabilities. While the private copy levying is generally permitted, it still impacts the income of creators and rights holders who need to be remunerated. The stakeholders propose that a new provision be introduced to create a levy to be charged on devices that are capable of duplicating and storing the copyrighted works. Honourable Chair and members, our proposal is that we maintain the position of the Honourable Attorney General that the proposal be rejected because the committee, when he appeared in to present the bill, he mentioned the position. The proposal of the stakeholders has an effect on the increase of the cost of gadgets, which affects the digital penetration in terms of uptake of ICT in Uganda, which is a key driver to socio-economic development. Honourable Chair, Honourable Members, Honourable Attorney General, we beg to submit our proposals. Thank you very much.
Thank you. Thank you for taking us through your responses. Yeah, colleagues, you have heard, and you listened to our stakeholders, you have heard the responses. Is there any further clarification that you seek? Because now the issues are quite clear. It is now upon us to decide on how to proceed, but you may want to seek some further clarification.
Yes. Thank you very much, Mr. Chairman. I want to look at clause 5, I think page 1. The requirement for mandatory registration should be removed. I think that's what the stakeholders were proposing. I want more clarity on it because these stakeholders were like proposing that they use technical persons, they use lawyers to draft, to register, to do everything. And it's like you were concerned the proposal is intended to protect vulnerable creators who sign away their rights in unfair or opaque contracts. Don't you think the work of the lawyers and other technical persons would be infringed upon if you are looking at people who can even sign away their rights? How can a person who is able to create something again sign it away just like that? Another one is the 50 years and 70 years as provided for in the Berne Convention as you proposed. What's wrong if we take the 70 years, much as we are a developing country? what's wrong if we take the 70 years as it is provided for, and we maintain it so that we don't have to come back. I don't know which time we shall develop. I don't know we'll be here, so that they don't have to come back again to sit and talk about the same issue. The other one is the percentage of if you are using a callback. Yeah, on page 6, clause 11. The stakeholders agreed in principle with the proposal, but made a further proposal that in clause 11.2a, the author and the performer should be separated, and each should be given a clear percentage. Who determines the percentage? Who does determine that? The other one is related to the author and the performer. I'm looking at music, for example, where you find that music is done. I've been saying Celine Dion's song, I don't know which one, but there was that drum. Now there is a challenge. Who can drum it exactly when it was drummed for her to sing? Now, there was that person who was playing the drum, but there is this person who is singing. There is another one on the saxophone. There is another one for the song to come out. How do you determine whose rights are to be protected in that song, and how can that one be protected? For example, if you go to a Frigo band, for example, you'll find the other one drumming, one on a saxophone, but there is a performer. And the one we are listening to mostly is this one singing. And they normally say this is the song of so and so and so and so and so. But there is a line of other performers. So how do we protect that, so that when the payment is done, they also benefit in their performance? It is related to the other one which I asked last time, but you promised something which I'm still waiting. That there is this person who writes a song. There is that one. There is a performer. How does, if the performer of the song, if the singer is paid, he's not the author of the song, he's not the writer, how does the writer benefit? Because we shall be paying that one who is singing, the one we are singing, but there is this one who actually composed the song. How do we put it in context that all of them will benefit in their creation? Lastly is the artificial intelligence. It is on page 11. And you said, I think the whole world is grappling with it. I agree. But the only thing is that, why do we wait for other countries to do, and then we do? Because we still have a problem. We have the problem they are having. Can't we solve it so that by the time they want to solve it, we have already solved it, if there is a problem to solve, or if there is anything to do? Because I'm hearing it is the future, AI is for future consideration, since it is an issue that all countries are grappling with. I agree. If they are grappling, do we have also to grapple? So because others are facing a problem, can't we use, I think you proposed a policy or something like that, so that we can solve our problem ourselves, so that we don't wait for maybe United States or whoever wanted to solve. So they can even learn from us after we have solved the problem. I think that's all I have for today. Thank you very much for such a wonderful presentation. I am always happy when I see RSB. I enjoy listening to whatever. I enjoy everything. Thank you very much.
Okay, the Attorney General is proposing that we can have responses to that and then proceed. Okay.
They become cumulative.
No. It's on AI. Then you answer at once. Okay. I think I may be the last person to comment on AI.
Okay.
I want to thank you, Chair. My concern, you know, in the youth bracket, you say that we have the future ahead of us. But it is very apparent that we're already living in the future. AI has been here with us, at least for some time. It is not a phenomenon that you think has just come yesterday, no. It's been there for some time. And I'm much aware, Honorable Chair, that we make laws to suit the needs of our society. If we can address it the way we can in our own setting. Because when I look at the response that this is something of a future consideration, that means even there is no policy direction that has been taken by government to initiate the discussion on this issue of AI. So I think I share his concern is that my senior colleague Attorney General, that we need to have that policy, should be work in progress, to address this issue, because we can't. There are different settings. Ours is a different setting, we need to address it. So for me, the explanation that this is a future consideration is a bit of, it's self-defeating, that we've got to demonstrate that we have initiated something that we're trying to address our needs of our society. Thank you.
On AI, you might have to, don't answer, because there is a submission by LDC that was very resourceful on this matter. It is here. LDC was very resourceful on this matter. They even gave instances of, we already have some cases that have appeared in court on AI. I don't know whether I should do, is it very long? Let me ask my counsel to read it for us from the page. Read through.
Thank you, Chair. So the submission by Law Development Center on Artificial Intelligence and Intellectual Property, it's emerging issues. One is copyright ownership and protection of AI-generated works. The bill currently assumes human authorship as the basis for copyright protection, but AI-generated works produced autonomously by algorithms challenge this assumption. Questions arise as to whether such works should be protected, and if so, who should hold the rights? The AI developer, the operator, or another party. The requirement for human originality under traditional copyright law may exclude purely machine-generated outputs, creating uncertainty in the protection and commercialization of such works. Number two, use of IP-protected works in AI training. A critical gap in the bill is the absence of provisions governing the use of copyright-protected works as training data for AI systems. Many AI models are developed using large data sets containing literary works, music, films, software, or art, potentially without the consent of rights holders. This raises infringement risks and questions around fair use, licensing, or opt-out mechanisms. Where AI-generated outputs benefit commercially from training on protected works, there may be a need for attribution and fair remuneration frameworks to ensure equitable value distribution. Number three, regulation of AI-assisted content creation tools. AI-assisted tools can inadvertently reproduce or closely mimic existing works, leading to unintentional infringement. Clear rules are needed to define liability among developers, operators, and users while preserving innovation, through balanced regulatory approaches, such as safe harbor provisions or narrowly tailored exceptions. Number 4, automated rights management and licensing systems. Given the volume and speed of AI-generated content, the bill could be strengthened by enabling automated licensing systems, potentially powered by AI and blockchain, to manage rights, issue licenses, and track royalties efficiently. Such tools could improve transparency, reduce disputes, and streamline royalty distribution. Number 5, transparency and accountability in AI-driven enforcement. AI tools are already being used to detect infringements, block content, and issue takedowns. Without clear accountability mechanisms, these processes risk errors, biases, and overblocking legitimate users. Embedding human oversight.
Thank you so much.
That's enough.
There is that part where he alluded to a case.
Oh.
Can you look for it? There was a case in court that he quoted.
At the back. At the very back. At the very back. Here.
Take us through that part.
So there were case studies. Okay. So there was a case study, the AI-generated remix of Masavu by Azawi featuring the late Mose Radio. In 2024, an online YouTube user, YouTube channel Mva Kampala Records, recreated the late Moses' voice using AI and blended it into Azawi's song Masavu, and he provided a link without her consent. This was uploaded to YouTube and to this day continues to generate income for the uploader, despite the fact that both Mose Radio's voice and Azawi's original works were used without proper licensing or authorization. This incident highlights the monetary exploitation of AI-generated works in the absence of a clear legal framework, leaving original creators without recourse or compensation.
So you can now respond to those issues.
Thank you very much, Mr. Honorable Chair and Honorable Members, for the issues raised. The first issue related to Clause 5 in terms of the requirement for registration of assignments, licenses, and transfer of copyright. And our position as government still is to maintain the clause as is because of the advantages that we give. But maybe even to explain further is that we all appreciate the fact that copyright is a private right. And when you have copyright, you have moral rights and economic rights. The moral rights relate to the respect to give to the authors and of the rights and the issues that relate to recognition, non-tampering with the works that have been created, among others. The debate is on the economic rights. The economic rights indicate that give the authors of these works the commercial value of their works. And this is where we want to dwell as a government. How are these artists benefiting from the economic rights? To benefit from economic rights, there are many avenues and pillars that you have to rely on. We may see copyright as an intangible right, a musical expression, a work, a book written, a film recorded, a scientific work, or a computer app generated. And this is in the intangible world. If we relate it to the tangible world, where you have land, you can't own land. Yes, it's one thing to have ownership of land, you have a certificate of title. But if you want to lease it, there must be an agreement to lease. If you want to rent it, there must be an agreement to rent. If you want to assign it for a period of time, that's the reason. There must be something documented and relied on and given even the legal weight in terms of registration. So when you bring it to the copyright world, these are the realistic models of enforcement. So when you appear before courts of judicature or before the registrars or the Attorney General's chambers to claim that your work was is being infringed, you need to prove that yes, it was created. It's not mandatory to get a certificate, but the law says for evidential value, you may get a certificate of ownership. So the same way you get a certificate of ownership of land. But if there are other transactions on that land, and in this context, on that copyright, if it's going to be used as a coloring back tune, if it's going to be used, if your photograph is going to be used in an advert, if your book is going to be translated, used as a derivative work, translated or to be transformed into a movie, there's need for those licensing agreements that should be written and also registered to give them legal backing. It makes it easy in terms of enforcement, and it is for the benefit of the owners. Otherwise, we'll have a situation where people just assign rights by mouth, by word of mouth, like they have always done, or sign documents that they have not read or understood, and they do not define the rights. And at the end of the day, they lose these matters before the registrar or the courts. So we beg to maintain that the registration aspect of assignments, licenses, and transfer be maintained. It gives it that legal value. And these are things that have been tested since we started implementing copyright in the 1960s, and even the amendments that we had in 2006, and even the current. So it has been tested over time, and it will work out for the owners. So let's keep it as is. The period, yes.
I think they were worried that perhaps it would be expensive and therefore prohibitive. Maybe you could clarify on that.
Thank you very much, Honorable Chair and Honorable Wasarira. The costs of registration takes different shapes. Whereas it's not mandatory to register, but when you for copyright, when you register any document or any agreement through the registration of documents law, it is less than 100,000. But the government has gone ahead to reduce the costs in terms of taking away the gazette, the requirement to gazette, because that was also another cost to ease the registration process. But also what we need to understand is that I think it's also a mindset issue, Honorable Chair and members, that we are looking at tensions here. The tension in terms of compliance, where government comes in, compliance and regulatory enforcement, and the tension in terms of investment by authors and creatives. Let's take an example. An artist coming up with a video, they invest a lot of money, more than 20 million Uganda shillings. They pay for the hire venue, they pay costumes, they pay the dancers, they pay the instrumentalists, they pay transport. There are so many costs. So let's take a minimum of 30 million, 20 to 30 million. But this is where we say to secure your rights, all these rights where you have invested over 30 million, which are going to last you 50 years after your death. If you have lived for 100 years, that's about 150 years. Why can't we invest 50,000 to protect your works? So I think it's about priorities. They want to benefit from the work, which they have invested a lot of money, more than 30 million, 10,000 US dollars, but they don't want to invest in the protection, which is a small fee of less than $20. So you have to go an extra mile if you want protection. So otherwise, if we keep it that way, that the cost of registration is so high, but the cost of of creating the work is much higher. Is much higher. So the registration is less than $20 or $15, but the investment is over $10,000. So these artists must choose where they want to, the path they want to go with. The path of being enabled to protect their works at a minimal fee, or we could introduce, the Honorable Attorney General is here, free registration services for artists who are investing a lot of money. They can pay 30 million to invest in a video or even a work, publishers, but cannot look at the investment of less than 50,000 Uganda shillings. I think it's an issue of interest and priority, not an issue of the law here. Yes. Thank you very much.
As a matter of fact, I recall we did explain to them. I remember to explain to them the benefits of registration. Yes. I told them registration outweighs non-registration. But I was not so over than the fees. Maybe at that point I did have to equally argue with them. But they seem to be so troubled. They know God was really.
Honorable Chair, if I may add a little to the Registrar General's comment, let the law come into force. Let the registration exercise begin. If there are other mischiefs that appear along the way, we are here, we can always make adjustments. If people think that the fees is too high or it is too low, those discoveries will be made along the way and adjustments will be made.
You see, when you look at this bill, one of the objectives is to domesticate some of these international treaties and that Uganda has signed and ratified. And I recall in their presentations, they were making many references to provisions in the international treaties. For example, on the issue of registration, that I also recall, they were quoting a treaty that is to the effect that when you are registration is creating unnecessary formalities, okay? And yet the treaty, one of the treaties, I don't recall so well, one of the treaties that they were citing was it the Berne Convention? Yes, the Berne Convention. And the WIPO, I think the WIPO Treaty. Yes, which was to the effect that authors should not be subjected to any formalities. So as if they were making an argument that this registration runs counter to the provisions of these treaties. Maybe it's something you may need to provide some clarification on, Chair.
That one isn't that one on the works.
Yes.
That's on the works.
Clarify further.
But you can clarify.
Thank you very much, Honorable Chair and Honorable Asman Basalira. Indeed, Uganda has ratified all international treaties relating to copyright, starting with the main treaty or the convention, the Berne Convention of 1886, the WIPO phonograms and WIPO treaties that are coming on board, the Marrakesh Treaty, among others. The society must appreciate that there are theories behind these treaties. A treaty of 1886 at that time was encouraging many people to come on the register by saying that there are no formalities. And indeed, under corporate system in Uganda, even the law as is, there are no formalities in terms of anyone getting copyright. As long as the work is original and in terms of originality, in terms of you created it, and it has been expressed in terms of if it is a song, you sing it, if it's a book, you write it, if it's an artistic work, you draw it, if it's a sculpture, you design it, there must be that expression and a medium of expression. So those are as long as it is original and you have expressed it, there are no format, you automatically get copyright. But the law, our law, the 2006 law, did come up with an extra provision, extra effort, that you may register your copyright for evidential value. Because in the digital age, yes, and it is optional. But now you have to balance between the evidence and our society. There's too much infringement, there's too much piracy. I know there are other avenues that can be relied on, the master copies, the metadata in the computers, the system. There's a lot of evidence that is relied on by the courts and the registrars. But it still stands that in Uganda, it is not mandatory to register copyright. But you may register for evidential purposes. That is the avenue. But the way the world is going, actually the discussions now at the world intellectual property level, these conventions of 1886, with the digital revolution that we are looking at, we must put more safeguards in terms of protection. But the artists have an option to go without registration or registration. But it also depends on the transactions. If you're going to enter a transaction with a telecom, for example, or a broadcasting entity to project your work, there must be something written. You're not going to use oral submissions that please play my work and use it for advert, and then there's something that should be relied on. So that's the evidential value that we're emphasizing on.
Creating uncertainty of registration and unregistration. If we're going by registration, I think we need to have clarity in the law that we're making. That let's have registration, and that is where we're moving. You have actually, yes?
The issue is that we cannot make it mandatory, because that would go contrary to. You cannot make it mandatory. As soon as you have created some work.
Okay, there's still through your chair. It must stay optional because we are parties to the conventions.
Yeah, but
it must stay optional.
If they have used the
for those who are smarter, if we may say, and want to gain a lot from their works and are so commercialized, they can go ahead and register. Yes. Because if you're an artist and you don't have any, you don't look at the commercialization aspects. You'll not even make effort to protect, or you're not even seeing the future in terms of inheritance or the legacies in terms of passing on your work. Because you also have to indicate it in your will, by the way. So if you indicate it in your will without even evidential value, it may be difficult for people who inherit your works, your property, intellectual property, to claim.
Okay. But as a committee, we must protect those who are not going to register.
Exactly.
Because their issue was that the registrar is only going to entertain those who have registered. So we must make it clear in the law that the registrar has an obligation to entertain all and help them in the
Mr. Chairman,
I think in light of what we are saying, the reason why we must be very careful with the explanation being given by the team, you have to look at clause 17. Clause 17, which is talking about inserting section 49A, and specifically subclause 4. Subclause 4, Chair, says the registrar shall not issue an order or notice for blocking, taking down, blah, blah, unless the owner of the copyright work has a certificate of registration as proof of ownership. I think this provision, Chair, must change. Because you don't make it optional there, and then here the registrar is entertaining because on condition you have a certificate of registration. I think that's why we should reconcile. Okay.
Yes. Yes, Honorable Chair. On that sub-clause, this one will be readjusted.
Okay.
I think even with certificate of registration or proof of ownership, not and or proof of ownership. This will be rectified.
And if the Attorney General read has said we are going to use the word may, I think it now covers everything. The only now small thing which they are adding there will actually solve the whole problem. Even those who have not registered will be entertained. But it is important if actually people are encouraged using their systems to register. I think it would be important for them and good for the future. If they sensitize them, it will be good.
Or they give them PDM. You can give them PDM money and they use it to register. If their problem is money.
Asumani, we will cross that bridge when we reach it.
Okay, we need to proceed.
Thank you, Chair. Through you,
Proceed with the response.
Thank you, through you, Honourable Attorney General.
The two clauses are now settled. The clause on the registration of works and registration of contracts. They are now clear.
Thank you, Honourable Chair, members, through the Attorney General. Indeed, proof of ownership takes different shapes, including the certificate of ownership, so there's no need to worry. And we have to maintain databases in terms of recordation, among others. So the question on 50 years, not 70 years, we also have to understand the rationale behind all this. You can even give these artists 100 years, but at the end of the day, we must balance the interests. Why do they regulate the period of ownership? And this is your life plus 50 years after death. And this is for a single work. But if it is for a joint work, actually the joint ownership looks at the death of the last. If you're 10 authors of a book, it is until the last one dies that it applies. Or members, it is until the last one dies for joint works. So you can hold it even for 200 years. Yes. I will take it also to the patent system. The patent system does provide for 20. Yes. Yes. So, yes. Yeah. So for the period of 50 years, it is the basic practice all through actually African states, it is to allow that when the 50 years after the death of the author, the work should be in the public domain to be utilized by whoever is interested, and it's no longer protectable. So I think we need to balance between the 70 and 50 years, and we thought that 50 years is more sufficient to encourage creativity and more innovations among others. But it is also implied for the joint works that you can hold it for more than 50 years after death. The other issue is the collaring back tunes, the issues relating to determining of the percentage. I think the clause is very clear. The clause is very clear. It has provided this, and it will be enhanced even better by the regulations. Clause 13 does provide Part C. Clause 13, 11, Clause 11, Part C, provides that an aggregator or any other person involved gets 8 and 5%, 8 and 5 points percent for as their benefit. So it's already catered for. There's no need to worry. Issues of relating to the authors, performers, issues relating to Celine Dion and the band. We must appreciate that there's copyright and neighboring rights, but there are also key players. They are performers, they are authors, they are different players along the value chain of creation of this work. And all these are regulated by the contract system. If I hire somebody to play a guitar in my song, I have hired this person and I've paid them off, so they can't come and claim any copyright in my work. If I hire anyone to write a book, my book, authored by me, I have hired them, and our terms of reference are to the extent of that contract. I've paid them out, that is it. So they can't come to claim that they are the owners of this right. So it depends on the terms of contracts. And it also comes to the ownership. Who owns copyright? Ownership models of copyright can be, I can create the work on set, I can commission it, I can either get a consultancy to do it. As long as I've paid them out, they don't have to claim. They have no claim. Their rights are very clear. So,
Richard, it's like your law teachers claiming a portion of your earnings now. They taught you are now council earning lots of money and absolutely same situation.
So this also brings in the issues of the ban. So the circumstances determine the rights of the owners, and this is why we encourage the artists to understand their rights along the way within this legal framework, and document them and write them and make them clear, because we've seen cases where people have turned around that they played, they performed, and they were not paid, and so they claim to be part of the whole ownership. And that is the concept even of the neighboring rights. These are not rights, these are rights that support the whole performance system of the law. So they are catered for under the current law and even the bills. The bill, the AI, indeed, it has been discussed, the paper from LDC, and we maintain the position that this can be looked at holistically. But as far as the AI issues or development of copyright, our law still recognizes human intellect to create this work. There are many arguments around this. Even there's case law in the US and developed countries that have come up that how do we now change, and even there are also discussions at the world intellectual property level. How do we adjust in terms of who owns, the discussion is who owns copyright. Should it be only a human being? No, we should start looking at robots, robotics, and all these emerging technologies. That's a discussion that we cannot regulate at the moment, but we can have an AI holistic policy to look at this. But as far as creating of the works, using AI to create the works, they're already embedded in the AI systems that you use. Actually, when you look at the AI systems and apps that you use, they always do recognition. They respect copyright because they do practice the right of attribution. They indicate the source, because you have to indicate the source of that information. And even there are rules and guidelines behind the scenes that are signed by those platforms. So, and these are also signed on the behalf of the people that use these platforms. So that is catered for. The issues of the, I think that is, those are the issues that have been.
So how do we proceed on AI?
No, at the moment, regarding...
Attorney General, is there no way you can have those provisions?
As far as copyright is concerned, copyright protects, Honorable Chair and members, copyright protects literary works, artistic works, and scientific works. And it's a whole list, the broadest scope of protection in the intellectual property ecosystem. So any work that has been produced, behind the scenes, whatever you have used, whatever tools you have used, at the moment, we'll see the author, as long as it is attributed to you. The research models that you have used, totally, as long as you're not infringing anyone's work, it is attributed to you, the human being. We have not yet, at a global level, started regulating that AI can own copyright or AI can own anything. So we cannot now start regulating it within the copyright system. But we recognize the use of tools in terms of research, as long as the artistic work is attributed to you, as long as the scientific work in terms of computer programs and technologies are attributed to you, as long as the scientific works and the literary works, the works of literature are attributed to you, the human being. That is where we can, the scope under which we can operate. Yeah.
Other issue? Make a comment on clause 6, the one on the reversionary rights. You seem to insist that we maintain the clause, even when we have heard that the creatives, they were here and they said this is going to be counterproductive to their interests, because investors will have an issue with this, and all of them, collectively, all of them said this is not right. Why don't we leave this to freedom of contract?
Honorable Chair and members. Yes.
They were raising questions to us on the issue of reversion. They are saying, assuming you have sold your piece of land, to somebody, it is property. You have sold a piece of land to somebody. You know, this is my property. The creatives, this is my property. I have sold, I have disposed it of. Why are you, and the argument is that these creatives should be treated like any other form of property. If I own it, I can sell it, I can dispose it of. If I have sold my piece of land, if I've sold my piece of land, why aren't you saying that after 30 years of the land should come back to you, or 50 years? And they were raising those issues, obviously juxtaposing them with the, leases and licenses and what. It said, if I have my piece of land, I can agree to lease the land, and there will be a clause in the lease agreement. The lease is for 99 years or 30 years or 40 years. Why are you creating limitations on the creative industry? And I recall, again, as you grow older, memory fades. They were citing, again, another provision in one of those international treaties that seemed to be against reversion. If I get it, maybe I'll bring it to your attention. But that was one of the arguments that we received. Maybe you could also help to clarify.
Thank you, Chair, and through the Attorney General. Thank you, members. The rationale for this reversion of rights was due to the same artists that complained that they have assigned and licensed their rights without any period of reversion. So we were trying to address this gap. But where the artists or the authors are insisting that we should leave it to the freedom of contract, still we can leave it to the freedom of contract so that they regulate it themselves. Or in the alternative, we could just strike out the transfer aspect in the variables indicated, and we maintain assignment and licensing. So there are two schools of thought. We can strike out the transfer so that it relates to only assignments and licenses to give the minimum, but we can also, the other option is that we can leave it to the freedom of contract. We are using this as a best practice. In some countries, it's 25 years, 30 years. So, but if the stakeholders feel that they are going to do this themselves using the freedom of contract interparties, then as Attorney General's chambers and URSB, we have no objection. It can be regulated accordingly. Yes.
Chairman, I think it is it's good if they also want freedom of contract to take place. Let them have it that way. Yeah. Let them have it.
But maybe as you go forward, these individuals will have to be sensitized about their rights so that they are not exploited by a...
You learned that, Attorney General. Shoki was very clear on these things. Shokoro, you remember very well. If these contracts are being entered into through duress and influence, they will definitely be affected. So I think it's an area where we should not insist. Let's give them their way. Otherwise, the Shokoro will not be happy with you. And these days, you know, he's a pastor.
We shouldn't dwell on this, but I want you to understand the class of people we deal with, or those for whom we are trying to legislate. Sometimes they go to a promoter who has the financial muscle, and they get excited.
They are very tricky.
And they are easy to exploit along the way.
There is one, when they appeared, there is one who introduced himself as a Bablaka dog or something like that. Bablaka dog or what? Then I raised the procedure issue. I told the chair, he was in the seat. I said, Chair, this is a committee of recording. The proceedings are being recorded. This is a house of recording. Can people introduce themselves according to the names of national ID? The man insisted I'm Black Dog. We didn't want to waste time, and the record, I think, captured the Black Dog. So they can be stubborn.
Can we conclude? Yes, Honorable Secretary.
Chair, thank you so much. My concern is just about the issue of sensitizing. The line that Attorney General was emphasizing that we should make these people maybe aware of their rights and what. I think it should not stop on only this. It can just move across. Because here, I can tell that there are many laws there, though the law is ever silent, but we need also to put into consideration that as we are promoting the rights of these individuals, we must even know who is to take charge and what. So should not just leave it there, that we should maybe sensitize and what. Himself, on the behalf, yes, so everyone is...
Thank you. Okay, finally, we have PCL. Honorable Suman, you need to... Please. The idea of PCR, in clause, which clause is that? Private, it's a new insertion. The creatives are arguing that this is where the money is. If we need to help these people, if we are serious on helping the sector, our artists, this is where the money is. It's where the money is. You discussed it severally. The Minister of Gender was here and said it is their view that this matter should have been taken up. They were actually shocked that it was not taken up by government. And it is also a feeling in the committee that if we must help these artists to gain from their talent, this is where we can touch to ensure that they get some reasonable benefits. And so you claim that this will increase the cost of the gadgets. How about if we started small? Must it be a big figure that will upset the market? Yes.
Politically, I would advise that we should not go there now. Politically. Yeah, but we are politicians. My brother, now, the other day, we are striking because of taxes. Now, tomorrow, Chair, they will hear that we recommended to have a levy on these gadgets. These voters will beat us, Chair. We must be very careful. So the timing of the bill is not very good. So I want to think that the view espoused by the Attorney General, in the meantime, should be maintained.
Yeah, Mr. Chairman, at first I was dismayed, but because I had seen a clash where the office of the Attorney General and the URSB office, which in my wisdom I look at as the major enforcer. Mr. Chairman, you will recall that this bill had been brought by a private member,
and then taken over by the Office of the Attorney General of Government. Just a few minutes, I got some laughter when Director Massey conceded to the period of reversion, where probably we can do away with it. But realistically speaking, we need to look at the ordinary person, and I come in at the time when my colleague here is raising that the PCR should not be looked at. It is important, Mr. Chairman, to regulate the sector, but also to look at, because the artists and the creators are the direct beneficiaries of this law. So it is important, Mr. Chairman, sir, to categorically look at the issue of the PCR. As you said, as a committee, we are supportive. We need to support the sector, the beneficiaries in this, and not probably being waived by the season of politics. Mr. Chairman, sir, I personally expected the Attorney General to speak more than the Director is doing, because for her, she would literally enforce what we have passed. So we should not, Mr. Chairman, be swayed away from the facts and from what we had appreciated as the committee. Let the issue of the PCR private copy remuneration be considered as key in this bill, Mr. Chairman, sir. That is my humble request.
The voters. Because we must do our work, and blackmail now. For example, if we did 1,000 per gadget, what would be the effect? If we did 1,000 per gadget, yeah, 1,000 shillings for every gadget. How much would it translate to? And how much would it affect the ordinary person who is buying a smartphone of 300,000? So 300 and 1,000.
Clear that.
But
let's first start with the way we are starting. Then the emerging issues we shall now look at that. We will bring an amendment. I've now seen the direction you are going, Chair. Let us go.
Yes. Even practically, you recall, I put it to them in the meeting. I asked, is this money going to, are you creating a copyright fund? Do you have a circle? How are you going to share? Or how is this money going to, yes. But you recall, they didn't have a definite answer. They themselves were divided on this money and how it should actually benefit the individual, you know, artists or members of the creative industry. So I would think, my view, Chair, and the learned Attorney General is here, if there are other ways of helping the creative industry benefit from their creativity in the law, we should think along those lines without necessarily creating this copyright levy or whatever we want to call it. And I am very sure there can be different mechanisms without necessarily creating a cost that already the Ugandans are burdened with many forms of levies and taxes. I would think that the technical people must say, and these people, the dentales and all these highly technical people, could guide on other avenues in which we can use without necessarily creating a levy. I'm very uncomfortable, and as I said, I have put you on notice. Should it appear in the main report, I'm writing a minority.
Mr. Chairman, it is not a levy per se. When people hear of a levy, remuneration, it is private copy remuneration. That is one. Two, Mr. Chairman, sir. Mr. Chairman, sir. First of all, when you look at the intended amendment, we are talking of a registration of a collecting society as an establishment in place. Now, at the same time, we are also talking of a mandatory annual general meeting. People must meet and account for something. Whatever they will be accounting for, once we do not have this, you would look at the instance of the meeting, and it is purposeless. So there are three provisions here which are key. When we qualify, for instance, the registration of a collecting society, that is one. When we talk about a mandatory annual general meeting, that is two. And on failure to conduct it, there are penalties, heavy penalties. Now, these people must be meeting in regard to probably economic rights. If they have, say, if for instance they have this PCR, if there is some remuneration that money is collected where lumps, something that brings them together, it is not a levy per se. It is a remuneration. Yeah, it must be understood well in terms of money. No, members, let us not run away from the facts, because we had initially appreciated this. Mr. Chairman, sir, I wanted to bring out the issue of the mandatory annual general meeting, where they have got to meet to look about their economic rights. And one of them shall be this, the PCR. So we need to qualify this as earlier on talked about or agreed upon.
So these arguments should have been in our in-house, but they're appearing here. So without prejudice to that, kindly respond and we conclude the meeting. Without prejudice. But we will have a debate in our in-house meeting to determine on how to proceed, but without prejudice.
We still insist or hold the position as Attorney General's chambers that this proposal has the effect of increasing the cost of the gadgets and affecting the uptake, okay, of ICT at a time when we should be encouraging every other person to use ICT in the country. Perhaps going forward, the law come into place, and I'm just repeating myself, I've said this before. Along the way, you will be seeing other mischiefs coming. Then we can either consider a review or see what can be done along the way, once the law is established. Thank you.
With that, I once again wish to ask the Attorney General to make your concluding remarks. If there are any issues that have not been talked to, you could do.
I am very happy that we were given this opportunity, because people out there are very much interested in this bill, and we are dealing with a sector that works with the media a lot. There has been a tendency to distort and misreport some of the issues discussed. I believe what has been done here has clarified everything. I'm also thankful to the chair for that segment on AI from LDC, which we had not been privy to. But we all understand that this is a learning process, and learning never ceases. We need and the lawyers know that copyright is not a very, very few lawyers, specialize in it. But with the the changes and these laws, perhaps more people will be more interested in it, and we can make use of it going forward. I want to ask, I've seen a guest seated behind there, a professor I don't want to introduce. I'll be interested in his presentation. Perhaps Honorable Asumani will share with me a copy. Thank you very much, Chair. Don't mind about me and Asumani and the professor. Thank you.
Thank you, Honorable Attorney General and your team, URSB and the team. Thank you so much. I think now the issues are quite clear. It will help us further in considering the matters. You are discharged for now. Colleagues, we have Council Robert Kirunda is here from Center for Law and Emerging Technologies. Just remain seated. We receive his The meeting is called order, and the program is as follows. I have some copies here. We have already had a prayer. So the next item should be self-introductions. We will start with the hosts.
Honorable Chair, thank you so much, and honorable colleagues, our guests. And I'll declare a conflict of interest, Honorable Chair. At Mr. Chirunda. First, I need to express. Okay. Robert Secretary is my name. I'm a member of Parliament, Bamunanika County, Rural District. Mr. Chirunda is my teacher.
Wow, that's good.
Good.
So today you will see how you deliver. All right.
Chair, my name is Bosco Kirol. I'm a member of Parliament representing the people of US, UK, and that's in Katakwi District. Happy to be a member of this committee.
Taught by Councillor Kirunda.
I am very old.
Thank you, Chair. My name is Nsanja Patrick Kayongo, MP in Tenjeru South, which is situated in Kayunga District. I am a member of this committee. Thank you.
Our staff.
Thank you, Chair. I'm Gamusi Andrew George. I serve as a clerk on this committee.
Thank you, Chair. Sheila Atua, Council.
Now we are going to have introductions from this side. Who is the leader of delegation? How about this gentleman? Okay, then we can change the chairs. I thought he was good. So you can use the other one. Good. So you can now take us through your site.
Mr. Chairman, members of the committee, first of all, thank you very much for making the time to receive us here. My name is Robert Chirunda. I am the convener of the Center for Law and Emerging Technologies based at the School of Law at Makerere University. I am also the founding and managing partner of Chirunda and Company Advocates. I wear two hats. I came with a long list of colleagues, Mr. Joet Kaigulo, who is one of our researchers at the Center for Law and Emerging Technologies.
Want to hear them talk about themselves.
Thank you.
Good afternoon, everyone. I'm Kaiglo Joet, and I'm a member at Makerere University at the Research Center, and he's my teacher. Thank you.
Good afternoon. Good afternoon, Chair, honorable members of Parliament, ladies and gentlemen. My name is Olga Karunji. I am a Tech Policy Fellow at the Center for Law and Emerging Technologies. I am also a Senior Associate at Chirunda and Company Advocates.
Good afternoon, Chair, and honorable members of Parliament and everybody. My name is Aine Raymond. I am an associate at Chirunda and Co-Advocates and the head of disputes at the firm. Thank you very much.
Good afternoon, everyone. Thank you, Chair. Owen Mubalia is my name. I am a researcher with Center for Law and Emerging Technology, and I'm a student at Makerere University. Thank you.
As Chief Justice, Makerere University. Thank you. Good afternoon, Chair and honorable members. My name is Tyra Precious Trisha. I'm a student of Makerere Law School and a member of CLET Research.
Good afternoon, Chair and all honorable members. My name is Mbaba Zilia Owase, and I'm a research assistant under the Commercial Law Department of School of Law, but I'm also a research assistant under CLET, and I'm from Makerere University. Thank you.
And here, Chairman, my name is Baka Stephen Mugabe. There is full house. Mr. Kirunda, thank you for that. My name is Baka Stephen Mugabe, Chairperson, Committee on Legal and Parliamentary Affairs, MP Bukoli County North, and a member has just entered. Kindly introduce yourself.
Chairman, my name is Basali Rasman, MP Bujiri Municipality in Bujiri District.
Thank you. The next item on the agenda is communication from the Chair. Mr. Kirunda and your team, we are so grateful to have you here. We're at the tail end of considering the Copyrights and Neighbouring Rights Amendment Bill 2025 when we received your request to appear before the committee, and when the clerk informed me that Mr. Robert Kirunda had requested to appear before the committee, we readily accepted the invitation, the request, and decided that we invite you to come and appear before us because we are convinced that you are going to add value to this process. We have actually been considering this bill for the last 3 weeks, and today was supposed to be the last day. As you have seen, we invited the URSB and the Attorney General to try to knit the loose ends. But I told the clerk that no, with Mr. Kirunda, we must listen to him because there's definitely going to be value for our time and helping us to understand probably even the bill better. So we thank you for coming. Colleagues, thank you for keeping it here up to now. It's a very difficult time for you, but you have given this activity a very good time. So we thank you for coming. So the issue is we are going to be listening to Mr. Robert Kirunda. At all, we no, it was purely out of the understanding that is there's going to be value addition, definitely. Yeah, sure. Yeah. So we are happy to have you here. We'll give you 30 minutes to take us through your memoranda, and then we can interact with you for about 15 minutes, total 45 minutes. Thank you. You're welcome.
Mr. Chairman, thank you very, very much. First and foremost to you and to the honorable members of the committee for making the time indeed at the very last minute. And I am hopeful that my colleagues and I will really make it worth your while. If you permit me to go straight into the reason why we're here, the Center for Law and Emerging Technologies focuses on bridging the gap between 3 critical areas: policy, advisory, and academia. Many times those of us in the ivory tower wait for the laws, then we blame the parliament that passed them. We have taken a different approach, which is to criticize by creating, to contribute to the process, and we're hoping that our engagement here will be a part of that. The second thing that I must say from the beginning, Mr. Chairman, is I must express my gratitude to the people that you see me with here. This document is not a one-man effort. This document is a collective effort of all of us, and you will note that a good number of them are actually final year students at the law school. We're trying to mentor the incoming generation of lawyers. The third thing I must point out, Mr. Chairman, is that we've tried to take a different approach. We will comment on the bill, its strengths, and where we see some room for improvement, but in doing so, we have taken the liberty of drafting what we propose as additional provisions, should you choose to adopt them, and we hope that that might make the interaction more engaging. Mr. Chairman, moving on to why we're interested in the bill, we believe that Uganda stands at crossroads with the Copyright and Neighbouring Rights Bill. This bill offers the country a chance to move beyond incremental modernization and towards continental leadership in the creative economy. The creative economy is a really critical part. And so our presentation outlines a comprehensive framework on building on the bill's foundations, which we've understood to be international treaty domestication, enhanced penalties, fair use updates, collective society streamlining, anti-counter circumvention measures, to addressing critical gaps and positioning Uganda as East Africa's creative hub and Africa's copyright innovation pioneer. Mr. Chairman, we'll explore a strategic approach we'll explore this opportunity for regional competitive analysis, and we do this via 6 key framework components, including, and we believe that each of those 6 elements is constantly aligned and would not be challenged. We'll try and do this in 20 minutes to allow more time for interaction with the committee. Mr. Chairman, strategic opportunity that, as we understand it, is that the bill successfully demonstrates the treaties, the Berne Convention, the WIPO Copyright Treaty, and so on. However, it misses strategic enhancements that we believe are needed for leadership. Kenya amended its law in 2022 and realized a 400% digital registration increase. Rwanda's VAT on digital services and Tanzania's telecom progress highlight Uganda's risk of falling behind without bold action. With a 5% digital tax and only $40 million in tech investments compared to Kenya's $638 million, Uganda must balance tax policies with superior creator protections. The framework we are presenting to you today proposes first-mover advantages in AI copyright, digital platform regulation, and mobile creator economies to attract investment and foster innovation. Mr. Chairman, I hope we spend some time on AI. I caught the tail end of the discussion with URSB. I must say at the forefront that I take the opposite view. I believe for reasons, we believe for reasons we'll articulate very shortly, that we need to regulate this space now. And we'll say why and we'll propose how. We have set out what we believe to be a regional comparative analysis, but I will skip that for brevity and just very briefly outline the 6 framework approach that we suggest. Number 1, how do we maximize the digital platform economy regulation? The current Act Section 8 lacks specific provisions on digital streamlining platforms like YouTube, Apple Music, and Spotify, where Ugandan creators lose revenue due to absent oversight. As a solution, we propose a platform accountability framework. We propose amending Section 8 to include digital distribution rights with mandatory revenue sharing, ensuring creators get at least 50% net proceeds. With the new Section 8A that we proposed in this document, we suggest that you as Parliament mandate platform registration, transparent quarterly reports, and algorithm disclosures and dispute resolution mechanisms. I happen to be a creator of music. I found that in making one song, you need at least 16 players. What happens is when you are paying the producer then decides who gets paid how. Technology can solve that problem. After you then put your music on Apple Music, where my music is found, you literally lose control of how do you even start to trace and to hold these players accountable. This is a problem technology can solve, and we propose how. The second pillar of our framework, Mr. Chairman, is artificial intelligence and copyright. AI-generated content poses new challenges absent in this bill. We propose, number 1, refining an author in Section 2 to include human oversight of AI works, and introducing Section 3A for judicial flexibility in determining AI authorship questions. Masavu is a common example that comes up. Azawi sings a song, a young man sitting in his bedroom uses AI, adds Mose's voice to the song, Mose radio is deceased, you have 2 songs. Assuming this dispute went to court today with the current Copyright and Neighbouring Rights Act, how should a judge determine that dispute? Is this young man entitled to any rights in copyright or not? Does Azawi claim infringement or not? Can the young man say it was not me, it was the AI? You can't leave that question unanswered. Because if you do, you're telling the judges to decide as they might see fit. But that question is not a question for tomorrow. That question is a question where I'm talking about a song that I suspect everyone in this room has listened to. Furthermore, I write a paper, the Honorable Asumani authors a paper. A trainer of a large language model, such as ChatGPT, uses that model to train the large language model. How should the Honorable Asumani hold that large language provider accountable? You can't leave that to chance. And we can't say we'll wait for the US or the EU or Japan to regulate, then we'll move forward. Because the beauty with these technologies is they affect everybody. Mr. Chairman, we propose a set of sections on how to deal with those issues. For instance, in Section 5A, which we propose that we introduce in the bill, we propose protecting AI-generated works with human supervision. This is what in AI is called the human-in-the-loop approach. But in the entire process of AI generation and AI use, where is the individual and who do you hold accountable? The debate about whether to regulate AI or not really stems from 3 major arguments. Number 1, it's too complicated. you know what, we'll figure it out later. Number two, it's moving too fast. Yes, but you know what, there are foundations we can deal with. Number three, you know what, the companies are too far. It's none of my business. Well, guess what? Today, AI can compose a song faster.
Just a minute. Sorry for interrupting you.
Yes, Mr. Chairman.
Colleagues, you had our interaction with URSB. They seem to be, they didn't understand what we wanted. They did. Now we are hearing, just like we heard from LDC, this matter must be regulated now. So I propose that we pick a lot of interest in this matter. We could come up with our own sections as a committee, because we have that space in the rules to introduce our own clauses. So some of these could be adopted. Council, be very careful, be attentive, such that we see how to adopt some of these as our own clauses from the committee, because the government seems to be not interested in. I thought what they would say is maybe let's go back and engage the Minister of ICT. They are talking of the future. So this is very good. Yeah. You are out of order, Honorable. Out of. So, Honorable, proceed. We are giving you a lot of attention on this matter. Proceed.
Thank you, Mr. Chairman, and thank you, Mr. Chairman, honourable members, and I am glad and gratified. And I believe I speak for my colleagues when I say we are grateful that the committee has taken a lot of interest. What we have proposed, in fact, Mr. Chairman, if I may suggest to you, is we've set out 8 different provisions. We've even drafted the language. At least suggestive. We don't claim to be experts in legislative drafting, but at least to guide the members of the committee in how to think about this. Because the starting point, the Registrar General is right in saying the current act says an author must be human. That's the standard across the world. Guess what? In the end, when the question goes to the court and the court says the author must be human, go away. I can't determine if the author is or if the work is original or not. What you have done is you have said, let the question remain unanswered. There is a way to solve that problem. Simply talk about, we propose 2 definitions. Number 1, amend the definition to factor in the role of a human in using AI. Because you see, AI doesn't dream up this stuff on its own. Somebody prompts it. There's a human behind it. Number 2, there's an accountability issue here. There's a lot of litigation in the US currently about the use of copyrighted material to train large language models. The New York Times has sued ChatGPT. Authors have sued, the Writers Guild in Los Angeles has sued. And by the way, talking about the Writers Guild, the movies we watch were written by people. Now they are not written by people anymore. A lot of scripts are written by AI. So is the music on Spotify. Now, if you said don't regulate, what happens to the Ugandan authors who play in that space? Basically, what you are saying is, if you don't protect the work of the Ugandan author, the American who builds a large language model can use that work unprotected. Number 2, if the income, you see, many people miss the point on disruption. Disruption does not happen when your job is finally gone. For me as a lawyer, disruption happens when my client whom I advise is disrupted, because then I have no one to advise. So if my client is Swang's Avenue, who is a collection of artists, and those are now being disrupted by kids who take their chords and make songs, I have no client to pay me. That is disruption. And you can't, we can't delay this and say, wish it away. So what happens is we propose Section 5A, what are AI-generated works and how do we supervise them? How do we hold people who are training large language models accountable? We must require consent. If you want to use the work of if you want to use my work that I have authored, then you must come for my consent before you do so. But if I discover that my dissertation or my work which I wrote, a book that I wrote, was used to train a large language model without my consent, I should be able to sue ChatGPT. I should be able to sue Google. They are not too far. And by the way, the idea that these companies are too big to be held accountable does not work. So what we've done is proposed a framework on how to hold them accountable. Mr. Chairman, we propose sections 5D, E, and F, which add protection to non-fungible tokens. Section 5C adapts a work for hire to trustee obligations. You have a very simple concept in copyright. If I employ my colleague Raymond, and he works as an associate at my firm, and then he generates work, because it is work he did in the course of his employment, that is the work that belongs to the firm. There's 2 issues here. The first issue is the argument has been a non-human cannot get intellectual property rights. Well, here is where that argument is flawed. Companies own copyright and patents. Companies are not human. Now, what then happens to the individual who in the course of his employment uses AI? The more we leave this space unregulated, the more we are saying that work is unrecognized. It doesn't mean the work does not have value. But can we even answer the question, is that original work? It's that simple. Is that, in fact, what is the test for originality? So we propose the wording of these provisions. How should a judge sitting with the work to say, was the rendition of Masavu an original work, or was it a violation of an existing work? It's a simple question. A judge in Uganda must answer it. They need to have a section on which they can say, this is the framework, here's how we go about it. So, Mr. Chairman, we propose that, and the real impact is that it's not just on music, it's on photographs. It's on art. Uganda has an artist who is renowned in the world. He's, in fact, known worldwide as a beat king. His art is exhibited in galleries across the world. Assuming I take a picture of his art, and I throw it in Nigerian computer and say, produce for me an image, what happens if the algorithm spits out something that looks like what this gentleman took his painstaking time to create? That is the Taylor dispute on copyright in the US, a photograph generated by AI which looks like someone's original work. What happens? Is there infringement or not? So it's not just about saying, oh, it's too complicated. It's also about protecting our artists today. And when we point out the real impact here, we say a photographer's image cannot be used to train AI sims without their permission and fair payment. There's two things. There's permission, there's payment. And then number three, there's accountability. Mr. Chairman, we go further and talk about our third pillar is advanced collecting society modernization. Can we use mobile money and other platforms? There is a company in this country called Songboost. Songboost does a service which, as a musician, I wish I had discovered earlier when I made my music 6 years ago. What Songboost does is it tracks airplay and is able to say at what time a song was played, for how long, on which station, and when. In other words, technology now exists that can help people who have no access to holding players worldwide accountable to being able to leverage that and getting paid in real time. Go back to my 17 artists, the guitarist, the drummer, the acoustics guy, all of them in my chain of making one song. How do I make sure that each of them gets a fraction of the 1 million shillings I pay for this song? Technology will solve that problem. One way to do it is leverage mobile money, leverage existing payment systems, and these technology tools and platforms that can manage and control that approach. Mr. Chairman, we propose provisions to that effect. And then we have a comprehensive creator protection system where we are saying beyond contract registration, we propose adding sections 39A and 39B and section 4A to establish robust protections, including dispute resolution and moral rights enforcement. We hear about neighboring rights. But have we actually examined how these rights can be enforced? How do I prove a neighboring right? What happens if that issue comes up in the digital space? Mr. Chairman, because we are a Center for Law and Emerging Technologies, our memorandum is heavily and densely based on technology. But we believe that that is the value addition that we bring to this committee. And then we have international comparatives. The bill does a fantastic job in bringing us up to speed on our international commitments. However, we propose a few more additions. Sections 43B and 42B to promote mutual recognition of AI and digital copyrights, aligning with WIPO treaties, and this enhances Uganda's global standing and attracts foreign investment. I would like to invite URSB and the Attorney General's chambers to run a financial analysis on what happens if you attract investors here to come and shoot movies. I think it is well known now worldwide that one of the most famous scenes in Wakanda was shot in Fort Portal in Uganda. What I am not sure of is whether Uganda made any revenue on that. But we can't ignore that. We have some of the best sites. The Kasubi tombs are world recognized as a UNESCO World Heritage Site. Can somebody explain to me whether anybody, the Buganda Kingdom or the government of Uganda, has ever reaped a single penny from the photographs that have been shot about the Kasubi tombs? What happens when I use these photographs to train AI? How do I hold these players accountable? And if somebody in Germany uses work that is copyrighted by the Baganda, or that should belong to the Baganda by nature, and we've talked about traditional knowledge in our proposals as well, how do we trace these people? How do we hold them accountable? That's what the international frameworks should help us with. We should be able to use these frameworks to leverage mutual recognition, which is common across many legal frameworks in this country, to increase the revenue that we make. Lastly, Mr. Chairman, the sixth pillar that we talk about is innovation-friendly research and education framework. As an academic in Makerere, and as an academic who has taught law for the last 17 years, I can tell you, one of the most unfortunate areas of copyright law, of intellectual property law in this country, is the imbalance between the power of the universities and the generators of knowledge that work there. I am not being critical of my employer as Makerere University. I am just saying perhaps it is time to revisit and to mandate all universities in this country to give fair and adequate recognition to the creators of intellectual property. This is what we saw with Covidex and Professor Guang in Bara University, and this is what we will see if we don't, because one of the historical reasons for copyright is incentivizing intellectual ability. Maybe it is time we revisited the frameworks on which universities can do this by statute, not just by university policy. And Mr. Chairman, we have proposed some provisions to that effect. Mr. Chairman, I want to make sure that we have enough time, so I've browsed very quickly over the 6 frameworks. But in summary, the framework that we propose to you in this document transforms the 2025 bill into a leadership vision addressing AI, platforms, innovation gaps, and positioning Uganda as a creative economy leader. We urge Parliament's swift action to seize the strategic opportunity that we have as Uganda and to improve the bill by addition of these provisions, should you deem it necessary. And with that, I thank you very much, Mr. Chairman, members of the committee, and we welcome your questions.
Prof, quite comprehensive.
You know, Chair,
yes.
I was poking my senior that he may not have anything useful to add, but I know it's But I want to thank our lecturer. You've really done justice to bring us to speed with one of the grey areas that was left unattended to. For me, that is, you see, if we can't deal with it during our time and we push it forward, we are simply doing a disservice. Law is supposed to address the current concerns of society, and we're living in an era where AI has attacked us. So we can't shy away from it. I want to thank you for the presentation. Surely, as a committee, this is going to enrich us to have a good deliberation on how we can help our country to resolve that issue of AI. Thank you.
This is a highly technical area. The Landlord Attorney General was here conceding that, you see, these things are not easy. It is not the time. So if the Landlord Attorney General is saying, who am I? I think we can only thank Professor Chirunda for educating us as a committee. And I am very sure it is an area where we need to do, the chairperson of the committee should arrange to do a benchmarking on these things in the US. We are talking about the other members will go, me, I can't go. You know my problems there. They can't allow me there. But other members can go and do serious benchmarking. Yes, this is an area where I think, Chair, we need a lot of knowledge and guidance. I have just one request to make, not directly related, but it's a neighboring right or neighboring related issue. The issue of, you talked about incentivizing the industry. This proposal of having a copyright levy, because it has everything to do with technology. Gadgets are coming here, different gadgets, and are being used as, you know, they play music, all sorts of things. And the creative industry is insisting that if this parliament does not create a levy, they will not have done a service to them. That the best way in which they can benefit from this law is if there is a levy on all gadgets that are imported into the country, and monies go to a fund and it benefits them. I don't know, as a scholar and researcher, how you'd guide on that question. I thank you, Mr. Chairman.
Something small. I'm also appreciative. Would want to thank the team for the resource. The URSB was here. They indicated to us that image rights are not a copyright issue, and that they are individual, they are under personality, and that they are already regulated under the Constitution and then protection and the privacy law. I want to understand from you whether that is sufficient to cater for the artificial intelligence. Thank you.
Yeah, I think let's have.
Mr. Chairman, thank you very much, and thank you, honorable members. Maybe let me start with the second question. I happen to have litigated Ankansime versus Uganda Telecom, which is in fact itself an image rights question. And on the basis of that dispute and the emerging jurisprudence in this country, I would argue, number one, that it is, in my view, in my very humble but considered opinion, not entirely accurate to divorce image rights from copyright. Because image rights in and of themselves flow, or the violation of image rights essentially arises out of the use of copyright material. For instance, in Ankansime shoots an advert for UTL. UTL then gives the advert to NBS. NBS and WBS play this advert without her consent. What makes the advert famous is not the content, it's the person. But what is really protected in the law today is the production, is the copyright. You can't have one without the other. Now, are these two, is the framework on individual rights and contract and the kind of framework outside statute sufficient for AI? Absolutely not. Because as I said, there are a number of layers to this AI problem. Image rights will arise as an individual. The most I have is my voice, my face, one of the impacts of AI is it's creating new asset classes. Think about the Mose song, the Azawi song, Masavu. Can a dead person enforce copyright? Because the voice was Mose's voice. Is it still his voice if he's deceased? Those are complex questions. That can't be in image rights. But it's an AI question. And that, in our view, needs to be in the statute. What happens to this kind of work? How do you classify it? Is it original? Is it not? So our view is that when you come to the space of image rights, separate the person who is asserting the right from the material in which the right is expressed and the ownership of that material. The second part is covered by copyright law, and as it is today, based on our submission, you will tell our view is the law is insufficient, but it definitely needs to cover it. The first part really just is what gives rise to the second. So the two are interlinked, and one can't delink them. To the Honorable Asmani's question, the question of a levy is a very, very interesting one, and I think there's two ways to look at it. Number one, you raised, and I happen to have been here when you ventilated the issue, you raised a legitimate concern about taxpayer apathy. In the end, whether you call it a levy or a duty or a tax, as long as the payment coming out of a purchaser's pocket, they will see it no other way. The thorn will prick just the same. That's the first thing. But the second thing, and I enjoyed the discourse between you and the Honorable Chairperson, when he asked, why not put 1,000 shillings? The thing is, the moment you put 1,000 shillings, there's no reason why it won't become 10,000 tomorrow. Once you open the gate, you've opened the gate. Now, for me, the larger issue for our colleagues in the, and there's value in saying, let's help the industry raise revenue. But can we think about more creative ways to help the industry raise revenue? For instance, if we regulate YouTube, Netflix, Spotify, Apple Music, and the young people here will tell you 10 other platforms I don't even know. Why don't we take a fraction of that revenue and give it to the industry? Because then the person who is paying is not even feeling they're paying. Many people think YouTube is about data. Google doesn't sell data. If you think Google is another business, you are 5 steps behind. Google is in the concentration business. Google is in the behavioral business. What they're influencing is behavior. If they are profiting from the behavior of Ugandans, then they should pay a levy for that. Now, that I would support 100%. Why? Because even I, who is contributing to that value by putting my music on YouTube, if they're not going to pay me, at least let them pay the industry. I don't feel the pinch. But given where the fatigue is now on the tax regime, I would be hesitant to go that far. Because in the end, once you open the door, you are far more schooled in politics than I. You can tell me how the optics play out. But I would think that there are more creative ways. For instance, we have not even begun to tap the value that is in AI. And if we get this right, if we start to think around the legal framework now, and we start to think about how do we create, generate, and retain value from AI, let me tell you what will happen. I no longer need to be, for instance, I am not a gifted singer, I don't know how to compose, but I can sing a hymn. That hymn was a long time ago, it's in the public domain. If I give it a new spin, I have a work of art. Now imagine what the young people who are digital natives will do if you give them the right tools and allow them to understand that they will profit from using those tools.
If I had my good lecturer well, among the things you do is you look at issues of policy. And you have led us to a direction where we want to think that we should be able to think along the line of the legal framework. And you're much aware, we are grappling with one absolute issue. A policymaker just sat here and showed us that actually they have not even thought about a policy along the line of AI. So where do we find ourselves the footing? That we are thinking in the legal framework and the policymaker has not yet even thought of the policy. So have you done something to address, to give a proposal to what is in the policy line?
Yes.
Thank you.
Mr. Chairman, through you, just to respond, I am aware, because at CLET we have also been involved in doing a legal and policy audit for the Ministry of Science and Technology. We are aware that, and we have made recommendations in this same direction towards a policy framework that is measured and long-term based and so on. There is a challenge, however. We found ourselves a chicken and egg situation. And this is what prompted our reaching out to the committee. We were not sure that we will have another window this close to put these provisions forward in the Copyright Neighbouring Rights Act. I think there's two things. Number one, a policy can lead to actionable provisions of the law. A policy can also lead to strategic direction, at least as I understand them. So our proposal is that we take a two-pronged approach. The first is that through this committee, the House puts in place the 8 provisions we've proposed are the bare minimum, the starting point. How do you hold platforms accountable? How do you define AI work? How do you, that's the starting point. When it goes to how do we maximize value, our colleagues at the STI Secretariat, then I am aware that are working on a detailed policy framework, and we are working with them closely to say, let's talk about how to maximize this thing in the next 1, 3, 5 years, and there is where you're then going to measuring the impact, the numbers, and so on. So the short answer to your question, Honourable, is yes, indeed, we have made those proposals, and we hope that the Ministry will take them. I thank you.
Thank you.
Thank you, Chair. Good afternoon, colleagues and visitors. Doctor, thank you so much for the guidance. My name is Odoi Onen. I represent the youth of Eastern Region and member of this committee. At UCU. Yes.
Thank you, Chair, and apologies for arriving late. I'm coming right from the constituency. My name is Oseku Richard Oriebo I represent Kibale County in Palisa District. I'm a member of this committee. Greetings to my lecturer there. Thank you, Doctor. Okay.
You see, this issue of the levy, looking at Professor Chirunda's presentation, I want to humbly request. You remember I was telling the Attorney General and his team to abandon it, but find space within this law to create alternatives on how best the industry can be helped and supported. Because definitely people must benefit from their thinking, from their works. In terms of legislation, and when you are responding to the issue, you did confirm that there are really other ways in which the industry can be supported without even necessarily looking at the levy or what we want to call it. You even did mention that we have, for example, not fully exploited the different media platforms, YouTube and the like. In terms of legislative proposal, and through you, Mr. Chairman, I would want to request Professor Chirunda here, just like he has done for AI, going through his document. You request that he makes some legislative proposals along those other lines of helping the industry without necessarily talking about a levy. Then maybe as we are, because here I think colleagues who are here, the proposals that have been made on AI and in the presentation are proposals that I think the committee can adopt, and we include in our report and we introduce them on the floor, because the rules allow a committee to actually produce, to have proposals. Maybe we could also, if it pleases Professor Chirunda and the team, they could benefit from many legislative proposals along those lines. Mr. Chairman, through you.
Honorable Sumani, my understanding is that this document is self-contained. My understanding is that these provisions are there, except that he has not taken us through the nitty-gritties, but the provisions on holding platforms, social media platforms accountable, they should be there. I don't know, you are going to respond. But I have a thinking that everything is here. Actually, I was just going to direct our secretariat to extract. And but that's what I think. Because from my understanding, this thing of PCR is pedestrian. That's what he has actually said. It is pedestrian. There are better means of extracting money from the sector without necessarily going into levying a phone, 10,000. How about if the levy goes to 100,000? That will be so prohibitive. So I think they are there, but without prejudice to your response, you can respond.
Thank you, Mr. Chairman, and I'm grateful to the Honorable Sumani Basalira for his comments. First of all, we at CLET would welcome every opportunity to contribute in any way that we can to the work of this committee and by extension to the people of Uganda. We would be grateful for that. Second, Mr. Chairman, you're absolutely right. The very first pillar in the proposals we've made to you on digital platform economy regulation touches on this. Because what is the challenge, the current challenge? Communication to the public by wire or wireless means, as is provided for in subsection E of the current Act, predates modern revenue models, while subsection G covers commercial rent or sale without addressing platform sharing. Now, if we start from the platforms, and the real impact, the example we give here is a Compliments whose song goes viral. By the time I caught on the craze of this old man who was dancing with his son, I had no clue what was going on. Please forgive me, I am a bit behind on TikTok. But this, apparently, in Times Square in New York, a video on TikTok goes viral. Think about what would have happened if there was a way for this gentleman and his father to earn revenue from TikTok. At that point, if you then interpose a levy in between and say, you collect your $5 from TikTok, we will take 2. I think that's a much better and much neater way because A, I have created the work. B, it has gone viral. C, even when you take a fraction of that, whether we like it or not, it is a tax. But at the end of the day, it is not the same as saying, I take money out of my pocket, add it to the price of my phone, and give it to the government, because I haven't yet benefited from the use of the phone. So in other words, I haven't yet seen a return, but you are taxing me on the purchase. That's the challenge. Now, where we could perhaps, to align with the Honorable Asmani's question, what we could do to amplify our pillar 1 is to go and now interpose that element. Can we say, for example, the same way it is with UCC, that under the UCC Act, there is a gross annual amount that UCC collects from all telecoms that goes into a fund. If the committee adopts our proposals on digital platform economy, we could then add in a rider, and this would be one of the reforms we would suggest, to say whatever is collected from these digital platforms, which by the way will be easy to enforce using mobile money and so on, and companies like the one I mentioned, Songboost, you then take a fraction of that and designate it towards the industry, let the industry grow and thrive from the work that it's doing. What will happen? 2 things. Number 1, you incentivize people to make Ugandan content viral because they are actually earning revenue. Number 2, you have a steady stream out of which someone who is buying a device but is not creating content, think about it, we all buy phones for different reasons. The Honorable Asmani owns an iPhone, perhaps for him, for aesthetic quality. My colleague Olga Karunji, now, what that tells us is that the Honorable Asmani Basariwa and also marries with taste. Now, now, think about it. He is not creating any content on that phone. Is it therefore fair to impose a levy on him because he has a device? Or, rather, more accurately, impose a levy on his wife because she wants to give a gift to the husband? That's the question. On the other hand, if somebody has the ability to make content go viral to 1 million subscribers, surely it is only fair to take a small fraction of that and kick it back to the industry. And I don't think they would complain. And I will close this point on the words of the famous words of that French finance minister. The ultimate art of taxation is in plucking the feathers off the goose with as little hissing as possible. Which of the 2 approaches would result in the least hissing possible? What we could do, the Honorable Suman, to your point, is we could, with the chairperson's permission, go back and look at Pillar 1, and I believe it is the Pillar 1 on digital platforms, and Pillar 3, I believe it is, on advanced collecting society modernization. We could look at how to enhance the proposals we've made there further, because you see, collecting societies themselves, in our view, have been underutilized. And if they leverage technology and get even more creative, there is so much IP in this country. I was flabbergasted when I went to Ndere Center once. Last story, Mr. Chairman, with your permission. I was talking to the proprietor of Ndere Center once, and he said to me, did you know that the British recorded folklore from every region in this country and protected it by copyright in the UK? That's just scandalous. My father, who, thank God, is still alive today, when we were young, used to have a Musoga artist who was blind. He was called Mata. That guy used to make music off a thumb piano and would walk around, and imagine what would happen if that guy had the way, using the mobile phone, to access revenue from his music. Now, if we then go into those frameworks and say, how do we tap a fraction of this as we create the digital flows? We will, A, incentivize telecoms to get in on the action. B, anybody can then earn from work that... There's things that will never interest me. Last example. The last game in Nambol is Uganda Cranes. I really have to salute the Cranes, and they've done us proud. Go Cranes. But something struck me. Imagine all the memes from the jerseys that people were wearing with the strange comment at the back. All it takes is one creative young person to make that into art and sell it, or make it go viral, make one of them go viral, and some are already viral. And if you monetize that, and then you take a levy out of that, I think we'll be going very far. And guess what? That's what makes America unique. America is what it is today because it is the one economy in which you can go to bed flat broke, wake up tomorrow, sell an idea for $1 million, and move on with life. Our proposals here are specifically aimed at incentivizing young people and the new economy, the creative economy, into moving in that direction. I thank you, Mr. Chairman. I thank you, members of the committee.
Thank you. Is there anything else? Mr. Chairman, one last one. The team is comfortable with the title of the bill, where it says for right and neighboring rights. Are you comfortable? The title, the name.
So, thank you, Mr. Chairman. Through you, Mr. Chairman, the short answer to the question is yes for two reasons. The first reason is technical. We stand to be guided, but given that the parent law, this one is an amendment, not a repeal, the parent law already has a name, I'm not very sure that we can change the name. But secondly, world over, this field, as disrupted as it is today, and by the way, there is scholarship from authors like Professor Mark Lemley of Stanford Law School. I have made the same argument in works I've written elsewhere, that copyright as we know it is dying. Generative artificial intelligence appends it completely and takes away the pillars. But as it is today world over, it is still the discipline of law as we know it, Copyright and Neighbouring Rights Act. What changes is that the scope of the neighbouring rights expands. When we go deeper into AI, we then say, can we talk about protecting prompt engineering as a skill, as a neighbouring right? In other words, if I write a really great prompt, if I frame the words that can cause AI to give me output, and full disclosure, a good amount of the content in this document was generated by AI. But one has to know how to use the tools to be able to get the kind of output that looks like quality. That's a skill. It's the same way that when we were young, I never understood what sound engineering was. Until you talk to movie creators and directors and they tell you, the soundtrack you hear, the music you hear before the guns start going off, that causes you to be anxious and sit on the edge of your seat, it takes genius to do that. And that person must get paid. Those areas are expanding. So I believe that the title of the bill as it stands, Copyright and Neighbouring Rights, in and of itself is appropriate, but what we must be careful to not miss out on is the fact that the scope of neighbouring rights in and of themselves must expand. I thank you, Mr. Chairman, and thank you, members of the committee.
No, I was just saying if it extends to capture the AI component now, but it looks like we will have to consider a new regime for AI. I don't know whether that is it.
Through you, Mr. Chairman, Honorable Seku, the proposals we've made actually provide provisions that the committee can add to the current bill, and once those provisions are added, with any necessary modifications, then we would have a starting point. It is by no means a comprehensive framework, but we must start somewhere. And that's what we propose. So currently, we need not wait for an entirely new regime. That's the view that we've taken, as far as the intersection between AI and copyright is concerned. I thank you, sir.
We need to come to conclude. We need to conclude now. And we have had a good interaction with you, Mr. Kironda, and your team. At this juncture, I want to give an opportunity to any member of your team to say something, anything they want to say, before we close. If there is anything to say. Your leader has said it all, but you might have something useful to add. And I can see her hand is up.
Thank you so much, through Mr. Chair, honorable members of Parliament. We are very, very grateful for this opportunity, and we hope that the opinions that have been rendered will be considered
to look at the policy of tax and levy, as you called it, when you look at social media, especially us as digital natives, it is an area that makes so much money, especially for the content creators, that is not taxed. When you talk to people that, first of all, are into fintechs, but also intellectuals and creatives, a lot of their work is not taxed because the government is not regulating it. So the first step is to regulate it, and once it's regulated, then you have a scope of what you can tax, because ideally the nation needs to grow through taxation and revenue. Secondly, on dispute resolution mechanisms, we will leave it to the committee to decide, but it's also very vital that dispute resolution comes up, because this is still an area that has not been litigated as extensively as, say, family or land law. But it is an area, because when you look at Ugandans, especially people, a larger percentage of Ugandans are youth, and the largest percentage of youth, if you have any 16-year-old, 20-year-old, you know how much time they spend using their phone. So a lot of that then needs to be regulated, because if it is up to the legislative arm of government to regulate, and it does not do its mandate, then that means that the implications and the consequences of their actions will overlap through generations. We cannot be the only country in Africa. Already there has been... Am I taking too much time, Chair? Thank you. Honorable members of Parliament, I only serve in the... Thank you, sir. I only serve under Makerere University, but still on that we have, this is protection for creatives, for FinTechnologies, for intellectuals, for academia. So it's a larger part of any developing country. If we do, as a nation that wants to develop, if we do not create entities to develop technology and to protect its users, then that means that ideally the digital markets and every single technology that comes up will not be taxed, will not be protected, and will still have the judges themselves that are going to apply this law will not have a basis. Thank you, through you, Chair.
Anything small again from anyone? Thank you. That was not small. That was big. So Mr. Kironda and your team, we are so grateful. The title of your presentation, Uganda's Path to Corporate Leadership Beyond the 2025 Amendment Bill, is worth the content, because in my view, if, for example, all these proposals were adopted, would definitely be very unique in the region. We would have many countries coming to benchmark on this. And so we are so grateful for your time you have taken to research. Point number one is that our proposals by Honorable Asuman, we request that you go a step further to help us narrow down those issues that we talked about. Number two, we further request that you keep your door open. We could consult you on any matter in relation to this bill. We could call you back to interact with us as a committee, or consult you in a written form, such that we can be able to get further guidance from you and further wisdom. So I'm now satisfied that my decision to invite you after the harmonization meeting was right, from what we have had. Now, our secretariat will have a bit of work to do. I direct that you go and internalize this document, pick out all the proposed legislative proposals that have been proposed, and then you juxtapose them against our rules to see if we adopted them, how much can we take on from the rules, because we have a limit from which we can take on. Number two, we have Article 93, which limits us to bring in provisions which have a bearing on the consolidated fund. You also need to study that. And then you also help the committee further to analyze, such that members have a comprehensive document of the proposals from Mr. Kironda. We have time, because from now we might not have another meeting. Probably UCC and NITA. We only have UCC and NITA next week. No, for them to analyze this document for our consumption, they need to analyze it, and also print enough copies for the members who have not attended today to be able to consume this document. It's very important. But our general understanding is that these proposals are very helpful. We are going to take them on, especially on AI. Raising revenue is very crucial. We are now thinking that we change the narrative from the pedestrian PCR to digital platforms. If we can get money there, that is better. So this is very good. It has been really worth the time, and we are so grateful that you came up to interact with us. With those few remarks,
Mr. Chairman, if I may I just finally thank you?
I'm going to give you time. Yeah. So with those few remarks, Secretariat, get on go to start the analysis I've said. Members, thank you so much. Let's give Mr. Kirunda 2 minutes to conclude with your remarks here.
Mr. Chairman, thank you very, very much. Just 3 parting shots. The first is to thank you and the committee, not forgetting the Secretary, Mr. Guma, was very, very helpful. Your technical team is very, very responsive. And I just wanted to salute them in your presence and to say what a fantastic team you have. Mr. Chairman, thank you for giving us the time. The second is to thank my colleagues most sincerely for their work on very short notice in putting these thoughts together. And to say, Mr. Chairman, that we remain available to support in any way that we can, if there's ever any need, even with Secretariat. If you need to discuss any of the provisions or proposals with us, we remain absolutely available and will do our best to give you responses to Honorable Suma and Basalirwa's comments swiftly. And last, Mr. Chairman, to appreciate the committee for taking such a positive response towards our thoughts, because it is troubling for those of us who create knowledge, who create art, if we see what AI is doing and yet hear the approach that the government is taking to say, too complicated, not now, not later, for the future. But we are grateful, and even on looking at digital platforms and the proposals we made, for your reception, and we remain available. And with that, we wish you every good luck with the rest of the bill. Thank you, sir.
Hello, Kampala, Uganda. In response to the national call of strengthening the traffic security, Good Products Group, HGO